My name is David Greene. I am senior partner at Edwin Co. And I sit within our arbitration and litigation department. And we are producing a short series in relation to arbitration, starting from some fairly simple concepts about what it is, why do people choose arbitration, and some of the elements of arbitration, and then moving on in due course to the more complex areas of arbitration, jurisdiction, questions about the seat of arbitration. But this first element is just to deal with some general points about what arbitration is, why people choose it. And first of all is that people ask what is arbitration? Well, arbitration is effectively a private court. You appoint arbitrators, and it may be one or two arbitrators, to adjudicate on a dispute that's arisen, usually within a contract. In order to resolve that dispute, hopefully by resolving it by a settlement, but otherwise by a determination by the arbitrators. What is arbitration? Well, broadly it falls into two categories: domestic arbitration and international arbitration. On the domestic front, it can have a wide-ranging application. For instance, many consumer contracts have an automatic arbitration clause, particularly, for instance, package holidays. But also it can be disputes between large companies over many millions of pounds or billions of pounds to resolve their dispute. Internationally, arbitration is very popular for particular reasons that I'll come to, but that tends to be cross-border transactions, either between companies or alternatively between governments and companies. There is a particular brand of arbitration that deals with those types of disputes where you have a sovereign state as one of the parties. Why do people choose arbitration? Well, first of all, it's regarded as neutral. And if you have an international arbitration, one of the parties or both parties are going to be concerned if the dispute is to be resolved within the other party's jurisdiction. They'll wonder about the neutrality of that jurisdiction and whether they can get a fair hearing or justice in those processes. They usually can, but there are those doubts. So arbitration provides a neutral forum for the resolution of the dispute. And very often that neutral forum could be something wholly unconnected with the parties themselves, and the law might also be neutral. For instance, you may have a dispute between parties, let's say one's in France and the other's in Germany, and they might not want to resolve the dispute within their own jurisdiction, so they might choose England as a neutral forum for the resolution of the dispute by arbitration. Second reason is it's private. Many disputes are of such sensitivity that the parties would require that they be held privately, and the arbitration process is private until you come to the question of enforcement. Enforcement is also a really important point about arbitration because you can enforce internationally an award given in arbitration under the New York Convention. And that has greater power, believe it or not, than a domestic court. So if you have a judgment from a domestic court, it can be questioned when you come to enforce it in another jurisdiction. Whereas, as long as the jurisdictions are parties to the New York Convention, then an award given by arbitrators is readily enforceable. And the final reason why people choose arbitration is it's flexible. You can have one or you can have three arbitrators, which is the normal, and they can use their procedure flexibly. And it's a really interesting area because it's often civil law and common law mixed, and they can take whatever process they want that they think is best for the procedure. So flexibility is an important point. Arbitration clauses are often an afterthought of those that draft the agreement. They're popped in at the end of the agreement, and usually they also deal with the question of law, jurisdiction, but have some provision for arbitration or resolving disputes through arbitration. Often drafters pick the clause from another contract or from somewhere else, or someone who's suggested to it and then pop it into the agreement right at the end. Now that's going to become really important when it comes to any dispute that might arise. And of course, it's written when the parties are optimistic, there's going to be no disagreement, they're all pushing in the same way, but often these agreements end up in some dispute. And when they do, everyone starts looking at the arbitration clause, the dispute resolution clause at the end of the contract. And the terms of that are all important as to how you're going to resolve the dispute and the nature of the arbitration itself. Sometimes arbitrations are what we call ad hoc, i.e. parties fall into dispute and then they say, well, shall we resolve this through an arbitration? That often happens. But more importantly, really is the terms of the contract and how it's going to be resolved. What is the arbitration? Now, for instance, first of all is when one looks at an arbitration clause, one looks at the law of the contract. And that's usually chosen by the parties. And that could be the law of England and Wales or the law of France or wherever. But that's slightly different from actually where the jurisdiction is going to be. You might have one arbitrator, you might have three arbitrators. 1, 3, both are very common. One word about having three is that, of course, you've got three people that you're going to have to pay, so they do become more expensive. Also, we have what we call institutional arbitrations, and so that usually means that the contract and the terms adopt an institution through which the arbitration will be processed. And here in London, we have the London Court of International Arbitration, LCIA. In Paris, we have the ICC, which is the International Chamber of Commerce, their arbitration process. And there are many of those institutions dotted around the world. And often the choice of the institution depends on the language of the contract or the jurisdiction. For instance, in Francophone world, the ICC is very popular. In the Anglophone world, the LCIA is very popular. I'm turning to, as a final item for this edition, the question of the seat of the arbitration. And when someone's drafting an arbitration clause, they're not necessarily thinking about the seat of arbitration, and it's important. But it is really an important element of the arbitration clause. Because when choosing a seat, you really want a seat of arbitration. That means where the arbitration is seated for jurisdiction purposes. You really want to choose an arbitration seat in a jurisdiction which is conducive to arbitration. Now, this has a long history, and it's a long and complex history, but if you have a seat of arbitration in a jurisdiction in which the courts tend to interfere in the process, I fear there are many of those around the world, then not only are you buying a bit of arbitration, i.e. dispute resolution through the arbitration, but you could also be buying rather long litigation that will then follow it. Now, in England and Wales, if it's the seat of arbitration, there is well-established authority from all the courts that the courts will interfere as little as possible in the arbitration process, and they will accept the concept that the parties are contracted to arbitrate, and that's their decision, and that's going to be final. So it's very difficult to appeal or challenge an arbitration award in the jurisdiction of England and Wales, which is why often it's chosen. But when you do choose a seat of arbitration, make sure it's one that is sympathetic to the arbitration process. I fear that judges in some jurisdictions feel that they want to interfere in the arbitration process. They'll accept challenges to it. And it really isn't what you want when you agree to an arbitration in another jurisdiction. So be careful about the terms of the arbitration clause. They are all important. Edwin Coe has been doing arbitration and helping people in arbitration for very many years. We do a lot of international work, but we also do domestic arbitration. And if you have a dispute and it has an arbitration clause, we can assist and we can deal with all issues that arise during an arbitration, both internationally and domestically.